The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Thank you. Please be seated. All right, we'll begin an argument in United States versus Artis. Ms. Lyston, be happy to hear from you.
Thank you, Your Honor. Good morning, may it please the court. Jenny Lyston for Ricky Artis. Your Honors, Mr. Artis seeks resentencing before a different district court judge. Now, we have raised a number of issues in this appeal, but with our limited time today, I intend to focus on the court's imposition of a warrantless search condition that it did not impose at the first sentencing. This search condition, which is designed for sex offenders, is not only procedurally and substantively unreasonable, it also raises a presumption of vindictiveness because it is considerably more onerous than the one that was initially imposed. So I intend to focus on this issue of vindictiveness.
That's where you get the idea that you ought to have a different judge?
I'm sorry, Your Honor.
You think you ought to have a different judge?
Yes, sir, we are
That's what I
asking
mean,
for that.
That's where you get the idea.
That's where,
But
yes, Your Honor.
Did you raise that?
We did not, Your Honor.
Well, that's plain error review, isn't it?
I'm happy to assume for purposes of our argument today that we are on plain error review, and that's all right, because I think we still win under that standard.
Tough standard.
It's a tough standard, but I think I can get there, Your Honor. So again, as to the presumption of vindictiveness, the Supreme Court and this court have made clear that it may play no role in a defendant's sentencing, and that any increase, any unexplained increase to the defendant's sentence raises the presumption.
Why is there a presumption of vindictiveness just because you didn't get the result that you want? And you're saying that we sort of impute vindictiveness to the trial court?
So again, this court and the Supreme Court have made clear that any unexplained increase in the sentence raises the presumption. So the question that this court has to answer is, well, what do we mean by an increase? Because that's the very first step in the analysis, right? There has to be an increase.
Before this district judge, you had a less harsh sentence on remand than before. Less imprisonment, shorter supervised release.
So I'd like to make clear that the term of supervised release was the same, because on count 1, which is the attempted robbery count, the court initially imposed 3 years. That's the statutory max. The term of imprisonment for count 2, I'm sorry, the term of supervised release on count 2, which was the 924C count that went away, that was the 5 years. The court could not impose more than 3 years of supervised release. So
I disagree with the search condition. That's, fair enough and everything, but that's really quite a step that you're asking us to take, which is to impute bad faith and vindictiveness to someone who, over the course of many years of experience that this court has had with him, I don't see any evidence of vindictiveness at all. I think he's a thorough, I think he is a thorough, conscientious judge, and I don't like the idea that he's being accused of something that has, over the years, he's shown no indication of.
So, Your Honor, I appreciate that. Thank you, Judge Wilkinson. However, I think the question at the heart of this case is, How do we determine whether there has been an increase in the sentence for purposes of the presumption? And our approach to that is very simple and straightforward. It is easy for this court to apply. It is easy for the district court to abide by. And that is, at a resentencing, the district court simply looks at the first sentence it imposed.
It went from 216 months to 204 months.
Correct, Your
That's
Honor.
12 months left.
That's correct, Your
It
Honor.
went from 5 years to 3 years on the,
It stayed 3 years. That was the statutory maximum that the court could impose.
You're talking about supervised release.
On the supervised release, right. But at the same time, the court imposed a much broader, much more onerous condition of supervised release. And we think that when a district court at resentencing increases any component of the sentence, that should raise the presumption.
What specifically made it an increase? What made it harsher?
Oh, so many things, Your Honor. So, the original search condition, which is at JA 84, simply says the defendant shall consent to a warrantless search by a United States probation officer or at the request of the probation officer, any other law enforcement officer of the defendant's person and premises, including any vehicle. The new search condition, which is at JA 119, takes away all the time constrictions, so you have to submit to the search at any time by any law enforcement or probation officer. So there's no longer the probation officer's request, right? Law enforcement could go in and search. It's not just person and premises now, it's any property, house, residence, vehicle, papers, computer, other electronic communication or data storage devices or media. That alone, just getting into the computer, the digital devices, that is a hugely
But the question is whether the search condition was reasonably related to the nature of the offense.
That's correct, Judge Wilkinson. Then that's sort of getting into my second argument about why it was not related to the offense. But I just wanted to, right before we get there, I just wanted to point out.
He shot a guy twice, tried to kill him, and he's gun jammed. That's the only reason he didn't commit murder. He got off kind of easy.
And yet, I don't think that is a reason to search his phone or computer, Your Honor. But I just wanted to point out a few problems with the government's approach to this vindictiveness, the approach that the government would have you apply, which is what they call a holistic balancing test. And I agree 100%, that sounds really good, that sounds very reasonable and judicious, but the moment you start trying to apply that test logically and consistently, you run into a number of problems, some of which were identified by this court in United States versus Chang. One, it is extremely difficult to compare different components of the sentence, right? It's, Chang says it's like comparing clementines to kumquats.
What we're reviewing here is the sentencing proceeding that took place below, and the sentencing proceeding that took place below, it's well explained what the trial court did, and see if I can find the explanation here, and this is the heart of it. The district court says that your client wanted to kill the victim based on the information before it. He says, your client brandished a lethal weapon and began firing almost immediately when he entered the hotel room. He shot McNeil multiple times at close range, quote, not because he is a good person and not because he thought better of it, but because the gun jammed. In fact, Artis thought he killed McNeil when he fled. And this man, as a result, is confined to a wheelchair for the rest of his life. And that's the heart of it. And we can fritter around the edges about this and that. But the question here is whether this sentence as a whole was an unreasonable act on the part of the district judge and some sort of abuse of the district court's sentencing discretion for what is an absolutely horrific crime. He intended, and he was, the only reason he did not commit a homicide was because of the gun jam.
It is a terrible crime, Your Honor. I'm not here certainly to defend that crime. I'm simply saying that those facts do not establish any reason to search Mr. Artis's phone and computer for the next 3 years. That's really not reasonably related. And Judge Wilkinson, if you will remember, I think about 2 years ago, you and I had the exact same conversation about Roger Locklear. And that was the same explanation was given for the warrantless search condition for Roger Locklear. The exact same condition was imposed, and in that case, Your Honor, you agreed with me that that had to be reversed because there was not a proper explanation as to why that, especially the computer condition, why that search condition was reasonably related and appropriate for Mr. Locklear. And that was a drug dealing case, Your Honor. I think there's even less basis for that search condition to be imposed here.
Up on plain error?
It was, Your Honor, and you reversed it on plain error. And it was based on United States versus Arbaugh, which is a published opinion by this court, which actually did have to do with a sex offender. And the court still said that in that case, in Arbaugh, that the explanation was insufficient for Mr. Arbaugh. Our case, obviously, Mr. Artis is not a sex offender. He has, there's nothing, this crime,
I mean,
yes, Your Honor.
I don't hold out any brief for sex offenders, but I would think that someone who is a would-be murderer is in an entirely different situation from the individual that you and I maybe talked about sometime back. In other words, there's we're talking about a more serious offense here, and the district court wants to make double sure that this individual is not up to, it's not just the gun, it's the combination of the drug dealing plus the fact that he tried to commit a murder in cold blood. So this is by several quantum leaps up. This is a more serious, the combination of drugs and guns and attempted murder would invite invite a different kind of search condition than someone who is a sex offender, and I can see that being overbroad in a situation. But these are different offenses.
And if the court had actually tied anything about the offense into the reasoning for why that warrantless search condition was necessary, especially to search the computer and the phone, then I might be making a different argument, Your Honor. However, I will say that, again, in Locklear, the exact same explanation for this exact same search condition was deemed to be insufficient under plain error review based on United States versus Arbaugh.
Was the explanation also insufficient at the original sentencing for the original search condition?
In this case, Your Honor?
Yes.
Yes, absolutely. And actually, the court just said warrantless search condition, which wasn't even the same search condition that was imposed in the judgment. So in the original appeal, in addition to the 924C count, we also made a Roger Singletary error, which I think, if the court had reached that, it also would have found that. So no, it wasn't sufficient at the original sentencing either.
But the judge did a little bit more this time, didn't he?
He said
He referenced 3553A factors.
He did, and this court said, again, in Locklear, that was just referencing the 3553A factors was insufficient.
Including the need for adequate supervision?
Correct. He said the exact same thing. And this court said that that's just That could be said about any defendant, right? That's sort of that little recitation that he did.
Well, if you do it in combination with other factors that are specific to the defendant, that might be adequate, correct?
If that were here, but I don't believe it is. I don't think there's anything that he said that would require a search of his phone and computer. Again, that is a condition that's designed for sex offenders. Mr. Artis,
The drug dealing here might well require coordination among other drug dealers, and they would be using a computer and phone to coordinate those offenses. And at any rate, the search condition was set forth in the PSR, wasn't it?
it was, Your Honor, absolutely.
And there was no objection to it.
There was no objection to it, yes.
I mean, this is troublesome because maybe the earlier case didn't, was on plain error, but when you have something like the search condition and you say, oh, this is just terrible and it exceeded what was done before and everything, when it's spelled out in the PSR and there's no objection to it, then, and we're dealing with a crime involving both drugs and murder, and the district court wants to make sure that this individual is not up to what landed him in prison in the first place. He's just being thorough and making sure that these crimes are not repeated, and this is a very dangerous individual.
So two things, Your Honor, I just want to make clear. There was no evidence that Mr. Artis is a drug dealer, right? That was the victim, was the drug dealer. This is an attempted robbery, so Mr. Artis is not a drug dealer. Second, Your Honor, all of those things were true in Locklear. It was in the PSR, there was no objection, the exact same explanation was given. So I would ask, Your Honor, that you follow what you've already decided in United States versus Locklear and vacate the warrantless search condition. Thank you.
Thank you. Ms. Fritz, we'd be happy to hear from you.
Good morning. May it please the court, Christine Fritz on behalf of the United States, asking you to affirm the judgment of the district court. Like my colleague, I'd want to begin with the warrantless search condition, and I'll begin the same place she did with vindictiveness. And defendant's sentence is not actually harsher on remand than his original sentence. Moreover, there's no reasonable likelihood that the change in the warrantless search condition is the product of actual vindictiveness. And for that reason, a presumption of vindictiveness does not arise. Now, the first step is looking at whether the sentence is actually harsher. We have a sentence that is 12 months less imprisonment and 2 years shorter term of supervised release. And yes, we have a differently worded supervised release condition. And in some ways, that condition does cover a broader area, a broader range of places to be searched, but it also does include a requirement for reasonable suspicion that was not present in the original sentencing condition. And it is hard to look at a sentence holistically in some cases. But in Chang, the court was willing to look at the sentence holistically. And it acknowledged that there might be times when, for example, a supervised release term is increased and a term of imprisonment is decreased on remand. And it indicated that that doesn't necessarily give rise to a presumption of vindictiveness. But you look at the sentence as a whole. And in Chang,
She's saying that this is inconsistent with something, a situation that occurred 2 years ago, the search condition is inconsistent. What do you have to say about that?
well, interestingly, I was also before Your Honor in that particular case. Locklear is an unpublished decision, so it is not precedential, and I think it is very different from the situation we have here. So if we're going to look at...
Just tell me why you think it's so different. I've explained to you why I think it might be different. But...
Well, I think first of all, all of these explanation cases are fact specific. And yes, the court at the end of Locklear did make reference to, for example, the nature and circumstances of the offense, the need for adequate supervision. But that shouldn't be considered in isolation, because the district court judge here said a lot about this individual, about the nature and circumstances of the offense, and the need for adequate supervision throughout the entire sentencing hearing.
Because of the offense.
Well, it was both the offense, and it was also the fact that this individual had 3 decades worth of criminal history, during which the court, in discussing his criminal record, noted that he was repeatedly flouting the rules. He was not able to perform well in supervision. The court walked through his criminal history and pointed out no fewer than 9 times when his probation was revoked, or probation or post-release supervision was revoked for failing to comply with rules. And that was also replete through the PSR, all of these concerns. The court said, at 108, the court says, his record shows me that he has failed often when he is out and even under supervision. Earlier in the same hearing, at JA 100, the defense attorney was trying to say, look at his conduct while he's been incarcerated. He's changed. He's broken this pattern. And the court's response to that was that half a century on the earth and his time as an adult gives me little confidence. This is a court that was gravely concerned not only with the dangerousness of this individual, as shown through his incredibly violent offense, but also through his pattern of being unable to follow the rules. And the court needed to equip the probation officer with the tools it needed to adequately supervise him. And I think that that is distinguishable from Locklear. It's distinguishable from Locklear because that comment about the need to adequately supervise, it's a shorthand reference to much of what the court had already said. I don't think it's boilerplate, but I think it's a district court judge who thought, I don't need to repeat what I have already made very clear throughout the hearing. And that is that this is a dangerous individual who needs supervision and who needs a probation officer equipped to handle someone with 3 decades worth of not following the rules. That is very different from what Locklear had presented.
I wanted to jump back to your first point on what makes a sentence harsher.
Yes.
I believe, but before we got there, you were explaining what was required in order to give rise to a presumption of vindictiveness. And you had
Yes.
the way you said it was a little different than I understood it. So could you repeat that?
So I think first, the sentence has to be actually harsher. And then second, in most of these cases, the court will ask, does the presumption of vindictiveness apply? So is there a reasonable likelihood that the increase in the sentence is the product of actual vindictiveness?
But as to that second point, isn't it enough that there's a harsher sentence imposed and then it's not explained why? In other words, there's a lack of explanation as to the harsher sentence, and there's a harsher sentence. And if there's no explanation, is that enough to give rise to a presumption of vindictiveness?
I recognize, so there are some cases where the Supreme Court and this court has recognized that there's a difference, where there's a different posture, that there are some circumstances where the posture is just such that a presumption of vindictiveness doesn't apply. For example, you pleaded guilty, then you went to trial, or it's a different judge. And I think that I'd like to point the court to an intervening event in this case that I think helps remove the likelihood that this sentence was actually the product of actual vindictiveness. And that is that on remand, the probation officer specifically recommended certain conditions based on the defendant's case. Now, the probation office is the entity that supervises the defendant on supervision. It reviewed his case and it said, based on what we're seeing with this defendant, we are recommending this particular warrantless search condition. So I think that that is an intervening event, and I appreciate it's not the typical posture cases where there's a category of cases where there's been a trial or there's a new judge. But I do think that that is something outside of the district court that explains why this is different. And in a lot of these cases where a probation officer makes a recommendation in their area of expertise, a district judge is inclined to defer to that, particularly in a case like this where there's no objection. There's been no concern raised by the defendant about the appropriateness of this particular condition.
You know, my original assumption was just that the probation office changed the wording of how it recommended this condition. Like I could have been wrong in this assumption, but I assumed that the probation office proposed how this condition would be articulated, and originally it articulated it the way that it was imposed in the original sentencing, but then they changed the way they did it. They may have been clearer about wanting to search computers and phones and such, and then added the reasonable suspicion requirement. But you're saying that the probation office in this case crafted this condition for this particular defendant?
No, I think that this particular language is a typical warrantless search condition. And this is kind of the standard language that the probation office is using in, I believe, 2023, when this case was resentenced.
Right.
And they determined that warrantless searches were appropriate, and they did that particular condition. Now, I will say that at the original sentencing hearing, in the 2019 PSR, the probation officer did not recommend any particular special supervised release conditions. Between 2019 and 2023, when this case was resentenced, there was a lot of changes in supervised release law, including Rogers and Singletary, and the need to make sure that the defendants had adequate notice of special conditions. And so our probation office has changed its practice, and where it is recommending special conditions, now those appear in the, in either, like here it was the resentencing memorandum, otherwise it'll appear in the original PSR. And I will say that, to my knowledge, back in 2019, the previously worded condition did tend to be one of the standard verbiage that probation used, and yes.
As a general matter, before we imply vindictiveness to a district judge, you would want to look at the sentencing proceeding as a whole, and you would want to ask whether there was something that was just arbitrary or ungrounded. The question as a whole is, this was it's not a vindictive sentence. The district court explained at length why he was given the sentence that he was giving, and it makes sense. And the overall sentencing proceeding, the district court was very careful with it. And what he did was, he had good reasons for what he did. It was well-grounded. This was not a vindictive act. This was an act which involved a very clear-eyed appraisal of someone who had a history of not following the rules, and of someone who did everything possible to kill another human being, and in fact condemned him to an entire lifetime in a wheelchair. And the district court felt that an act and an offense of this magnitude deserved a serious sentence. That is not vindictiveness. That is matching the sentence to the horrific circumstances of the crime. And if there was something arbitrary or wholly disproportionate or whatever of what the district court did, then yes, you would pull back the curtain and say, look, this will not stand. But here, any individual could understand why this individual, this defendant, received the sentence that he did. And you have to look at it, what the district court did as a whole. What the district court did as a whole, he did what we wanted, which was to explain it and ground it in the facts of the case and in the PSR. And there was no objection to it until we got up here. And then all of a sudden, we think, oh, what he did must have been wrong, must have been vindictive. But it was all that vindictive. Why was nothing said about it?
And I agree, and I want to point out that after Chang, there is no dispute that this is on a plain air standard of review for vindictiveness. In Chang, at 1050, the court said, upon hearing the sentence, defendant could have readily objected, citing Pierce, and giving court the opportunity to address the objection and perhaps avoid this issue on appeal. So this is absolutely on plain air review. Similar to Chang, we don't think that the sentence is actually harsher, nor do we think that it was imposed in circumstances that present a reasonable likelihood that any change is the product of actual vindictiveness. But if the court were to disagree, and for example, in Chang, the court thought it was at least arguable that maybe that the presumption should apply. In Chang, the court refused to reassign the case to a different judge, specifically saying, the judge below conducted thorough and reasonable sentencing hearings, and we have found nothing in the court's comments or conduct.
We wouldn't get to this thing about reassigning it to some judge if it wasn't vindictive.
That's true.
If we don't think that this vindictiveness stuff has some substance, we don't have to worry about it.
That's true. I'm simply.
Some new judge.
That's true. I'm simply pointing out that a finding, if the presumption were to arise, it is not a foregone conclusion that it must go to a different judge. And I'd like to turn back very briefly to the explanation for the warrantless search condition, because I wanted to respond to the idea that the defendant's not a drug dealer, or that his involvement with drugs had no bearing on this case. To be clear, the defendant has, I think, 10 paragraphs in his PSR of drug-related offenses. And he also admitted to having a substance abuse addiction to both marijuana and alcohol. So the court's concerns about drugs and being able to look for drugs was absolutely well-founded and supported by the record. And
The offenses he was convicted for were drug-related offenses.
it was also a drug-related offense. It was a Hobbs Act robbery of a drug dealer, the objects of which two were
And he got a break when the Supreme Court decided that the Hobbs Act robbery was not a.
Yes, it was attempted. It was an attempted Hobbs Act robbery.
That was the reason he was being resentenced was this Taylor decision of the Supreme Court on whether Hobbs Act robbery was a crime of violence. Is that right?
That is correct. And he received the resentencing.
A resentencing, right?
He
The sentence went from 216 to 204.
Correct. And given the court's thorough explanation at the first sentencing hearing, I would submit to the court that the reasoning for that 1-year reduction related to his good performance while he was in custody. But again, that good performance didn't alleviate the court's concerns that this was an individual who had an extended record of violating the rules, and that the probation officer needed to have the tools to address him.
And it's subject to the discretion of the sentencing court how to weigh mitigating and aggravating circumstances, and the judge took into account the good behavior you just referenced, but still found the aggravating circumstances to warrant the sentence that he imposed, correct?
Yes. And one more thing, I wanted to comment upon Arba, which is a 2020 decision by this court that had an abuse of discretion standard of review. And I want to point out that the conditions in that case were vastly different from the sort of condition we're having here. There in Arba, there were 4 conditions that had, according to this court, no explanation at all, and that provided for random inspections, including the copying of data of all computer, electronic communications, and other devices. It authorized the probation officer to temporarily remove those devices for more extensive examination. It prohibited the encryption, and it also required monitoring. So those were far more intrusive monitoring, and also Arba was a lifetime condition. When we look at these other conditions where the court has addressed the explanation and has been focused on computer-related conditions, they tend to be far more intensive and for the remainder of the defendant's life. That was the case in Ross, Arba, McMiller. Hendricks was 20 years, which was probably the remainder of that defendant's life after he served his time of imprisonment. So we're looking at more intrusive terms over a broader period of time. Here, we have a warrantless search condition that happens to extend to computers and electronic devices. In a case where there was a conspiracy between two individuals to rob drug dealers, this is an individual who himself has a lengthy involvement with drugs, and under the circumstances of this case, the court's explanation was reasonable. This was an appropriately tailored condition for this defendant.
One of the things, we seem to be litigating more over conditions of supervised release than we do often of the underlying sentence of imprisonment. And that is surprising to me in a way that people are attacking the conditions of supervised release. Well, I understand that, but very often the supervised release gives rise to more litigation than the reasonableness of the underlying term of imprisonment. And I'm wondering, perhaps this is an unfounded concern on my part, but I don't want to get in the situation where all of these questions raised about supervised release lead trial courts to impose more severe sentences and terms of imprisonment so that they won't be tied up in this endless thing about standard conditions and optional conditions and whether it was orally pronounced or whether it was not. But are we in danger here with all this litigation of undermining the utility of supervised release as a component of sentencing, or is this just an unfounded concern on my part? It could be.
I think that in the last 5 years that I've been practicing, I've been practicing in this district since 2009, and the last 5 years have absolutely seen a boom in supervised release related challenges. And I think between Roger Singletary and some of the other cases, that has presented more avenues for procedural and other challenges.
Apart from Singletary, there's been an increase, it seems to me recently within the past several years or so, of litigiousness over these supervised release conditions. And I think, supervised release is a wonderful way in which to reintegrate individuals into society and give them a second chance. I don't want district judges to shy away from it because of this constant barrage of litigation over every single, over conditions and the relationship between the district judge and the probation officer and it's not just Singletary questions. There's a whole bunch of them. But I'm just interested in whether this is causing district courts to rethink the utility of this. Is that?
May I respond briefly? I see I'm over my time.
I'm just interested in getting your thoughts.
So I think that the courts continue to view supervised release as a way to help ensure that an individual reintegrates into society. And I think that also the way this court has crafted the remedy for failure, if there's a failure to adequately explain a condition, this court has crafted a narrow remedy where it's only that condition is vacated and it's sent back for the court to consider whether to keep that condition, modify the condition, and to provide whatever explanation was lacking. For example, in Locklear, when this case went back, the district court, there was information presented to the district court regarding the defendant's possession of a cellular telephone. And in that case, the district court imposed the same supervised release condition, explaining that it was appropriate based on the conduct involving a cellular telephone and his poor performance on supervised release. So I do think that courts continue to view supervised release as a tool. I haven't seen any indication that judges are modifying their views of an appropriate term of imprisonment based on the procedural requirements for supervised release. And I think that the court's limitation of the remedy helps ensure that the district judges continue to
Just remanding on the sole condition.
remanding just on the sole condition ensures that this court receives the explanation that it thought that it deemed to be lacking, and supervised release continues to be an effective tool. Ultimately,
Hold on a minute, we're giving you some extra time here. Judge King, do you have any further questions?
I'm good.
No, Judge.
We don't have any further questions.
all right, thank you. The defendant received a more favorable sentence on remand, and we ask that you affirm it.
All right, do you have some rebuttal time here? We'd be happy to hear from you.
Just briefly, Judge Wilkinson, I do need to correct my friend about the resentencing in Locklear. The district court actually did not impose the same warrantless search condition. He got rid of the search of computers. And I actually didn't really hear her distinguish the Locklear case. And I just really encourage this panel to look at the facts in the sentencing transcript in Locklear, look at the explanation. It is virtually identical to this case in terms of the explanation and the condition imposed.
What do we do with the 3 decades of refusing to follow the rules, and it seems like there's a pattern over and over of an individual who just openly flouted the rules over a very long period of time. And previous regimes of supervised release had failed to do their job, and the district judge at the end said, I don't want a repeat of all that.
I don't think that's what the district court said. I don't believe that the district court ever,
That's what he must have thought.
and we can't read the district court's mind, Your Honor. And so, like I said, when the exact same condition was sent back to the district court in Locklear, the district court actually gave it some thought and said, actually, we don't need that computer condition after all. And again, I would also like to point out, and Locklear is unpublished, that's true, but it was orally argued, and it relied on Arbaugh. And in Arbaugh, there was my friend pointed out that there were a number of other conditions, and that's true, of searching the computer and the phone, but there was a warrantless search condition for that sex offender that this court nonetheless said what had not been properly explained, did not see the need for that particular warrantless search condition, and I think the same is true here.
All these matters are individualized, and all these sentences are supposed to be individualized, and the question you ask is, does the sentence fit the crime? And here, well, we don't need to go over this again. We know, we're in agreement on the fact that this offense was a serious one. You raised a lot of other issues.
And I'm happy to just stand on my briefs on those issues, Judge Wilkinson. I understand we have very limited time today, so I will stand on my brief,
I have a
and
question about the harshness.
absolutely.
What do you make of the requirement of reasonable suspicion being added to the search condition? How do we factor that into the determination of whether this sentence was actually harsher or not?
There's reasonable suspicion required for, of course, a law enforcement search, right? But not for the probation officer. So the probation officer can still do, the final part of that condition is the probation officer can still search the defendant. So I would agree that that is maybe one bit of benefit to the defendant, but I think it's vastly outweighed by all the other onerous conditions as a part of that search condition. And I did want to point out, Judge Maddox,
I don't read it that way. It says, unless I'm misquoting it, it says search at any time with or without a warrant, and then it gives the various locations. Upon reasonable suspicion concerning a violation of the conditions of supervised release or unlawful conduct by the defendant or by any probation officer. And I guess the grammatical structure of that suggests that even the probation officer needs reasonable suspicion. Am I misreading it?
that is not how, That is not how we would read it. We would read it, the probation officer does not have to have reasonable suspicion. But I did want to also point out, Your Honor, because you were asking about this sort of increased harshness in Chang, I would just simply point out that this issue, the one that I am raising as to how do we determine an increase in the sentence, was never raised or briefed in Chang. It simply wasn't, the government did not dispute it, and so the first time that issue was ever brought up was at oral argument when Judge Niemeyer asked a question about it. So I think there was, in Chang, they simply accepted the government's concession that the sentence was harsher, even though the term of imprisonment went down. So I just wanted to point that out. We would ask for you to at least vacate the warrantless search condition and send this back to the district court judge. Thank you, Your Honors.
Thank you.
Did you have any further?
No, I do not.
Okay. All right, we thank you very much, and we will come down and recounsel and move directly into our next case. All right, we're happy to hear United States v. Berry and Ms. Allen. We're pleased to hear from you.
Good morning. May it please the court. Amanda Allen on behalf of Mr. Dwayne Berry. There are two undisputed facts here. Mr. Perry's charges were dismissed in December of 2019, and 5 months later, the government decided to certify Mr. Berry, and the only provision under the civil commitment statute Mr. Berry could have been certified under is unconstitutional. But before I address the constitutional argument, I want to talk about why this case is properly before this court, because the government spent so much of its briefing on this issue and only about one paragraph on the constitutional issue. The government has two arguments as to why this issue is not before this court properly. The first one they lead with is judicial estoppel, and the second is waiver. For judicial estoppel, the government has to show that Mr. Berry would have relied on the statement in the pretrial order stipulation that he was undergoing competency restoration to his advantage.
What do you want us to do for this fellow?
Your Honor, we would like that, or we ask that the court that Mr. Berry be ordered released and to vacate the district court's judgment.
Order his release.
Yes, Your Honor.
And even though he's dangerous
Your Honor,
to the public and himself.
there was no finding that he's a danger to other
He's
people.
certified as dangerous.
He was certified as dangerous, and there are two,
Certified as dangerous.
on the merits, and there are two ways an individual can be certified as dangerous. Here, the district court found there was not a clear and convincing evidence or enough of a
Are you
nexus.
talking about the district court, you mean?
The Eastern District of-
Judge Britt.
Judge Myers, Eastern District of North Carolina, the district court,
Judge Myers made the decision in 2024, but Judge Britt had already ruled on it in 2022 on the delayed issue, the 5 months that you're talking about. He found it was reasonable.
So I guess two issues that you bring up, Your Honor, that I would like to respond to. With Judge Britt, that was at the motion to dismiss stage, and I certainly plan on addressing that. This is not a typical delay case that the Fourth Circuit has seen prior. Here we have a clear end deadline of December 17th, 2019, when the indictment was dismissed. As far as dangerousness, the district court found that there was clear and convincing evidence to support a dangerousness to property, but there was not enough of a nexus to establish dangerousness to others.
Make a 46A, a valid 4246A certification. You have to find, well, one of the things you would have to find was that the defendant had been committed to the Attorney General pursuant to 41D, and then that requires findings. And this follows up with on Judge King's question. I thought that the certification here under this provision required findings that the individual both suffered from a mental disease and that his release would present a substantial risk of bodily injury or serious property damage. And did the district court make those findings?
The district court made all the findings except with respect to a substantial dangerousness to others. The finding was based off for the dangerousness part was based off of dangerousness to property, which was based off of
I thought that the statute permitted serious damage to property as a basis
It does, Your
of certification.
It does, Your Honor.
It says or.
It does, Your Honor. I just want to make clear that the finding here was about property and not dangerous to other
Satisfied the
people.
statute. The ruling satisfied the statute. The law that controls this thing.
Your Honor, the judge did make a finding for the merits.
The Judge Britt ruled that it was reasonable. Specifically, the time period that elapsed was reasonable.
On the motion to dismiss stage, Your Honor, he did, but we appealed because that was incorrect. For
What's incorrect?
for the reasonableness determination.
Argument is, the reasonableness finding is incorrect. That's your
Correct,
position.
Your Honor. Correct, Your Honor.
Okay, and we would, your challenge to that, we would review for clear error.
Correct, Your Honor.
But the certification here requires that the defendant has been committed to the custody of the Attorney General pursuant to 41D. And that was in fact the case, and then after that point, the district court has to make findings about a serious risk. And you're asking us to say that the district court's findings, that if released, this individual would present a serious risk to bodily injury or serious property damage, and we somehow imply that these findings were incorrect?
I think we skipped a couple of steps, Your Honor. Mr. Berry's argument is that he was not in the Attorney General's custody under 4241D.
You've argued legal custody?
He is not in the federal government's legal custody under 4241D or under the third category that allows the government to certify an individual after charges have been dismissed.
Three categories to this, and
Yes, Your Honor.
I'm talking about category number 2. A person who has been committed to the custody of the Attorney General pursuant to 4241D. And I don't want to add a gloss to this statute and try to put in something that's not there, because looking at the plain language of the statute, it says, has the person been committed to the custody of the Attorney General? And as I understand it, I understand the charges were dismissed, but the statute itself just says, has the person has been committed to the custody of the Attorney General pursuant to 41D. And then findings, at that point, findings are made whether the individual presents a serious risk in the manner that you and I have discussed. And that seems to me, there are ways to try to complicate it, I suppose, but it seems to me, just reading the statute, only one of those 3 conditions need apply, and it seems the most logical one is condition number 2.
That's, Your Honor, where we respectfully disagree.
You say it's not number 2?
Correct, Your Honor. It's not number 2.
Why not?
The Attorney General custody period expired at the very latest on December 17th, 2019. Now,
The statute doesn't talk about that. It talks about has been committed. It doesn't put a lot of conditions on that. It says has been committed to the custody. Now, you argue that, oh, well, that must mean legal custody, but I think the Supreme Court has said a number of times that the word custody is most naturally read to mean physical custody.
not in this context, Your Honor. In U.S. v. Joshua, a published case before this court, the court acknowledged that there is a difference between physical and legal custody. And in that
Which
case,
did you refer to?
U.S. v. Joshua, a Fourth Circuit published case.
You familiar with Curbo? Are you familiar with
Yes,
Curbo?
Your Honor. Yes, Your Honor. And in Joshua, this court acknowledged there's a difference between legal and physical custody, and in the context of 4248, the court interpreted custody to mean legal custody. And I think that's what naturally the language of the statute has to mean here. In Comstock, this court has talked about, and why the constitutionality of 1448 was upheld, was because it was limited to those individuals who are in the custody of the federal government, therefore upheld as proper under the, or constitutional under the necessary and proper
You
clause.
want to get to your constitutional question now?
Yes, Your Honor.
What's your, and that's under what constitutional provision?
So the third category, the only category Mr. Berry could have been certified under here, is unconstitutional under the necessary and proper clause, Article 1, Section 8, and under the 10th
You
Amendment.
ever heard of Eichwander? How do you get around Eichwander?
Your Honor, I'm not familiar with
That's
Eichwander.
the constitutional avoidance doctrine.
Well,
If we can, if the case is resolvable on a non-constitutional ground, we don't mess with constitutional questions. We're not to reach constitutional questions.
Yeah.
That's Eichwander. That's the principle of the Eichwander Supreme Court case.
and I am familiar,
30s or sometime.
and I am familiar with constitutional avoidance, should this court not want to decide the constitutional
So
issue.
constitutional avoidance is we don't address the constitutional question unless we have to.
And if the, oh,
And here, he's in custody under that Section 2, as Judge Britt upheld in 2022, and as it was upheld again in 2024.
if the court decides not to address the constitutional issue, Mr. Berry can still be successful in his claim because waiting 5 months to file their certificate was unreasonable. Whether the court determines that Mr. Berry was under 4241D custody, which Mr. Berry was not, that period had expired, and in any event, waiting 5 months was unreasonable. And under the third category of post-dismissal, certification, that waiting 5 months was also unreasonable here.
But Judge Britt said it was reasonable. He found it was reasonable in 2022. He said the 5 months, the 4-month provision was, they explained everything about him getting transported from the one prison lockup to finally got over here to Butler and the examination at Butler. That resolved that he was dangerous and was accomplished in 5 months and was found by the district judge to be reasonable.
Yeah.
And that finding is binding here.
Your Honor, the court can review the district court's finding under clear error, and here, even acknowledging some de minimis time period has to happen between the restorability determination and when the certificate is filed, that window should be a lot tighter when there are no charges pending against this individual and they're no longer in the legal custody of the government. Here, the government knew that it was going to dismiss the charges against Mr. Berry. The government decided.
But how does that link up with the statute? I mean, the statute doesn't, the second condition in the statute, you've talked, and understandably, about expiration dates and dismissed charges and all of that, and you say, well, in this case, the charges were dismissed, and the lawful custody would have expired by this and that. But I just don't, I see the problem there is we're trying to add gloss to the statute. Congress could have put in provisos about dismissed charges and expiration dates and everything, but it said, you know, that's not what the statute reads here. All it says is that he has been committed, which this individual has been committed to the custody of the Attorney General. And then after that, there have to be findings that have to be made. The statute is a highly reticulated statute, and it requires, and there are also ways of seeking release where if the director of Butler or whatever certifies the individual is no longer dangerous, that goes a long way to a release. But what you're asking us to do, it seems perilously close to short-circuiting a very carefully reticulated scheme that Congress has set up for individuals like this. I can understand what they did. What this individual was leaving around were things that looked a great deal like bombs. And, you know, these are ever-present concerns for large numbers of citizens. And I'm just very nervous about being asked to play around with some of the language in this particular statute. This whole set of provisions was very, very carefully thought out.
Your Honor, the last thing I would leave you with, unless there's any other questions, is this court's precedent in U.S. v. Carrington and U.S. v. Searcy has decided that when you're looking at civil commitment, there must be a clear start and end date for when the government decides to certify somebody. In fact, in Carrington, this court, Judge Richardson, said that when the government files a certificate after the custody period has concluded, the individual can file a motion to dismiss, and it should be granted because it's important that the government abide by the statutory requirements of start and end times here to avoid the issue of a individual who's been deemed mentally incompetent to be held for a near indefinite amount of time. We ask that the court vacate. We ask the court vacate the district court's judgment. Thank you.
Counsel, you have some rebuttal time as well, so you save that.
Thank you, Your Honor.
be true, we'd be happy to hear from you.
Good morning, Your Honors. Jenna Petrie for the United States of America. May it please the Court. Mr. Berry's counsel spent a good deal of time talking about why he should not fall under the 4241D prong of 4246A. But, Your Honors, that's a misleading argument that will take us in the wrong direction in analyzing this case. Because what Mr. Berry is asking you to do is to ignore the decision of the lower court, to ignore the meticulous analysis offered by Judge Britt, to ignore the findings of Chief Judge Myers that Mr. Berry is a dangerous person, and to ignore Mr. Berry's own waiver and stipulation to the fact that he was subject to 4246A as a person who had previously been committed to the custody of the Attorney General under 4241D. And so what I would ask this court to do today is to affirm the decision of the lower court. As Your Honors aptly noted previously, 4246A is a three-prong analysis of which only one prong must be met in order for a person to be certified as mentally ill and dangerous.
The second prong is the most logical, is it not?
It is the most logical, Your Honor, and it's the most logical for a few reasons.
That's the one you rely on.
Absolutely, Your Honor. It's the only prong the government has consistently argued throughout, and I would note that Mr. Berry himself only ever mentioned the constitutionality of that third prong in one paragraph in his motion to dismiss. And so he also did not heavily rely on that prong either. And the reason that the second prong of 4246A is the most obvious is because beginning on December 5th of 2019, Mr. Berry was at FMC Fort Worth in Texas undergoing competency restoration pursuant to 4241D. He was there at the time that the court ordered the
You say
4240.
December the 5th?
December the 6th, Your Honor.
December the 6th.
Or the 5th, I apologize. December the 5th of 2019, Mr. Berry arrived at FMC Fort Worth to undergo competency restoration. And we see that in the joint appendix as part of his history of movement within the Bureau of Prisons. And so we know that that's the date that he arrived at FMC Fort Worth to undergo 4241D competency restoration. He was there on December the 17th when the court, the Eastern District of Michigan, ordered him to undergo that 4246 evaluation. Now, the problem, of course, there is that FMC Fort Worth does not have the staff capable of doing a dangerousness evaluation. It's simply that those psychiatrists and those psychologists, they specialize in competency restoration, not in dangerousness, which, as this court knows from United States versus Curbo, are two entirely different analyses. And so Mr. Berry needed to be moved. He needed to be moved to a facility that was capable of doing a dangerousness evaluation, of which, as we can see from the records, there were only 3 in the Bureau of Prisons at that time. He was ordered to undergo this dangerousness evaluation at the Federal Medical Center in Butner, North Carolina, where he had not been since 2017. And so even though the evaluator who had previously worked with him was
Y'all
still
were
there.
slow moving him, though, after that.
Yes, a little bit, Your Honor. And I think the court aptly noted in the oral argument during United States versus Carrington that if there's no room at the inn, unfortunately, there's no room at the inn. And that was true here because there are only a few facilities in the entire United States capable of doing these type of mental health evaluations. And as I noted for the court, there were only 3 in the entire United States at the time capable of doing both competency restoration and dangerousness. And that's the Medical Center in Butner, the Medical Center in Springfield, Missouri, and the Medical Center in Devens, Massachusetts. And so there was a bit of a backlog.
You know, I mean, a civil commitment is a sensitive issue because we normally think of confinement as something that follows on the heels of a criminal trial. And committing anybody without a trial is not something that you do casually. And when you look at this statute, you see that Congress was concerned about that very thing, and it didn't want commitment to be undertaken, haphazardly or whatever, or to replace the criminal justice process as the normal means for depriving someone of their liberty. But Congress approached this in a very responsible spirit and set forth this scheme in it. The bottom line of it is that, fine, we need to find out who's truly dangerous, and to prevent the release of people who've been adjudicated to be seriously dangerous. We don't want them released into the general population. And that's what we have here, that we would be running a serious risk of somebody who's plainly imbalanced, and to release that individual into the general population over the findings of Judge Britt, who's a very careful district judge. That would be a fairly rash step.
I agree, Your Honor, certainly. And I think this court beautifully explains the
The point is, nobody's being casual about this stuff.
Certainly not, Your Honor, and the government by no means was casual in this either. Now, while a lot of the actions that happened in this case happened before United States versus Wada was even heard by this court and argued, all of the factors that were considered by Judge Britt in making his decision on the motion to dismiss on March the 31st of 2022 did encapsulate not only Wada, but also Curbo. And so what Wada and Curbo tell us is that analyzing whether or not the government was reasonable in the time it took to certify a person, that the government must strive to certify a person in a manner that eliminates or at least minimizes the time that the person spends in custody waiting a determination on civil commitment. Now, it reminds us that this time period should not be so short as to not afford the government time to adequately assess a person's dangerousness, but it obviously shouldn't be so long as to allow a person to languish in a mental health hospital. But what's most important about this and what distinguishes this case from United States versus Wada is that Judge Britt noted that the government has offered, as required, an explanation of the physical, the behavioral, and the administrative obstacles that took place in the certification process that resulted in the time period that it took to certify Mr. Berry. And Judge Britt does a beautiful job, I think, of analyzing those here, but just to remind this court, at the time that Mr. Berry was ordered to undergo the 4246 evaluation, as I noted, he was at FMC Fort Worth in Texas. And that was on December the 17th of 2019. For some reason, perhaps the holiday season, the Bureau of Prisons did not get a copy of that court order until January the 8th of 2020, at which time they immediately designated Mr. Berry to the Federal Medical Center in Butner, North Carolina. Now then, of course, he needed to be moved to that facility by the marshals, and as we've already discussed a little bit, there was a bed space issue at that time where there was a high need for mental health care and not a lot of beds. And the reason for that, of course, is that we need to house mental health individuals or people suspected of having mental health problems in a safe manner. We can't be putting them in bunk beds in a gym. We can't have them sleeping in the hallways. They need to be somewhere where they can be safe and confined and to receive the medical care that they required, which is why Mr. Berry remained at FMC Fort Worth while he was waiting for
46A certifications. I mean, there was a delay here, but the staff shortages at Butner and the bed shortages at Butner have been publicized, or at least I've been aware of them. It was clear that the institution had bed shortages and staff shortages, and that it was dealing with a very long waiting list and was trying to contend with COVID-19. And so you're worried about unreasonable delay in the 46A certifications. But given the conditions at the time at Butner, as I say, which were generally of public knowledge, that you can understand why it would take a little bit. There just aren't enough beds, and there are not enough staff people, and there are shortages.
Absolutely.
And that's That happens.
It does, Your Honor, and I certainly hope that this court
It was
understands
in the
that.
pandemic, too.
It was. So
At the
Mr.
beginning of
Berry
it, right.
arrived at the Medical Center of Butner on March the 18th of 2020, which, as we all know, was
But are there-
right at the start of the pandemic, and then was,
You said there were 3 places they did these exams, and Judge Britt was told there were 2.
yes, I believe that Judge Britt was focusing on the 2 places that were conducting competency restoration, and that was specifically at the time, Fort Worth was one of them. It was a very small operation, but Butner and
He
Springfield.
quotes the government.
Absolutely.
As telling him Butner was only one of 2.
That's for competency restoration, yes, Your Honor. Now
That
for.
was the government part when the government was explaining to Judge Britt why there was this delay.
Yes,
That's
Your
what he
Honor.
did too.
And that was for the competency restoration piece. However, the dangerousness assessment could also be conducted at FMC Devens during that time, certainly further away from Texas than FMC Butner was. And Mr. Berry had previously been at FMC Butner, albeit again in 2017. But as this court noted, the COVID pandemic did begin in March of 2020. FMC Butner had 4 evaluators. They now have, I believe, 9. And so that shows us just what they were working with at that time. Dr. Lloyd, who was assigned to Mr. Berry's case, was carrying a caseload of between 25 and 35 restoration and dangerousness assessments at that time, and was assigned to Mr. Berry's case. And of course, she had to reacclimate herself with his case.
I think you set out a lot of, these arguments in your brief.
Yes, Your Honor.
I'm going to ask my co-panelists at this point whether they have further questions of you. Judge King, do you have further questions?
I want to ask one question.
Sure.
I will.
Absolutely.
One further question. Judge Britt found, instead, in his opinion, the time period that elapsed was reasonable. Therefore, respondent's motion will be denied. Is it the government's position that that resolves this case?
Yes, Your Honor. I believe that that resolves this
I
case.
thought that's what would be your answer.
And even if it does not, that issue was never again raised by counsel throughout the pendency of his 4246 commitment process, and it was never raised at the hearing.
And that time period that he's referring to is about approximately 5 months.
Approximately 5 months, Your Honor, yes.
Okay. And that, as far as you're concerned, that's the case.
That's the case.
Do you have another?
I have nothing else.
Judge, do you have any questions?
No questions, thank you, Judge.
Thank you so much.
Thank you very much.
Thank you, Your Honors. I ask that the district court order be affirmed.
Okay. Ms. Allen, we're happy to hear you in rebuttal.
Your Honor, for rebuttal, I want to talk about 3 issues. The first being that my colleague on the other side said that the government consistently argued that Mr. Berry fell into the second category, Attorney General custody. That's incorrect. In the Eastern District of Michigan, when the government filed its motion to dismiss the indictment, the government said that it thought that Mr. Berry fell into the third category of post-dismissal under 4246A.
Even
Then,
before the charges were dismissed?
the government filed the motion to dismiss the indictment and the motion to send Mr. Berry off to an assessment under 4246 at the same time. And at that time, the government said that it was the third category that applied.
Is it that the third category would apply once the motion to dismiss was granted? Or you're saying that?
Yes,
Okay.
yes, Your Honor. At least that's what I understand the government would have meant. Then, in the Eastern District of North Carolina, the government in its briefing below argued that Mr. Berry fell under 2 categories, the Attorney General custody and under Category 3 of post-dismissal. And then on appeal, the government has now focused on the second category of Attorney General custody. So the government's arguments about what category Mr. Berry has fallen under has been inconsistent. I want to pick up where Judge King had left off with, that it was a slow-moving process on the reasonableness analysis for Mr. Berry, and it was unreasonable considering what the government knew and when. As early as December 2016, the government had Mr. Berry's PSR, criminal history, Dr. Lloyd's analysis, Dr. Sconce's analysis, or competency assessment from earlier. At that point, the government could have filed a certificate, and it did not. A certificate only needs to meet Iqbal and Twombly standards because we're in a civil context here. The government instead waited until May 21st of 2020 to file a certificate.
Given that the clear error applies here, if you could just concisely address what makes the judge's, the lower court's determination of reasonableness clear error. Is it just really the totality of everything that you've placed on the table, or is there anything in particular that you think makes this clear error?
It's clear error considering the facts of this case, that the government just simply chose not to and has not provided an explanation why it did not file a certificate earlier, especially considering this court's precedent that there must be clear start and end dates for the purposes of civil commitment under U.S. v. Searcy and Carrington. And that's why there's clear error here, and especially considering where the discharges against Mr. Berry had been dismissed. There, I think, are consequences of a ruling that an individual who remains incarcerated beyond the dismissal of their charges can at some point become indefinitely civilly committed. And that's something that the U.S. Supreme Court has said is unconstitutional. And here, Mr. Berry is not facing any charges any longer, and is no longer in the legal custody of the federal government. The government also had said that there was waiver of the constitutional issue. There was not. The argument about what category Mr. Berry fell into.
Where in the statute are these provisos listed?
I'm sorry, Your Honor?
Where in the statute, where in the second prong of the statute, are all these discussions about expiration dates and dismissal and all the rest? I don't see them there. I wonder my concern is that we're simply elaborating upon a statute well in excess of what Congress actually provided there.
I think two things that can give the panel comfort about the interpretation of the statute here. Under the statute, there's an initial 4-month period that has a clear end deadline, and then you get additional reasonable time after that, which is if the court finds a substantial probability that you can be restored during this initial time period, or when the charges against you are disposed of, whichever is earlier. Here, the charges against Mr. Berry were disposed of, even if the court were to consider he fell under the Attorney General custody, were disposed of in December of 2019.
I think the textual perspective would sort of highlight a difference between what what the statute says in terms of the person having been committed to the custody of the Attorney General versus, I guess the way that you're interpreting it would be, what would be more fitting would be is committed, or just a different tense to that verb, because I think the concern here is that it's clear that this defendant had been committed to the custody of the Attorney General pursuant to 4241D, correct? So
But that,
you can pick up from there.
But that period had expired, Your Honor. That's our argument. But I don't think there's any discongruence in the interpretation of statute and what we are saying. We're arguing that the 4241D period expired. If the court's considering Mr. Berry in the D period, then the additional.
More than 4 months?
That's a separate issue here. Here, we're assuming that we fall into the second category of additional reasonable time period. The charges were disposed of on December 17th, 2019, thereby concluding the Attorney General custody period. And under Category 3, that period also expired because the indictment had been dismissed for reasons of Mr. Berry's mental illness.
I mean, we're having a very interesting discussion here, but I'm just not sure I see that I see it in terms of the statute. That's the problem, but anyway.
I have one additional question, Judge.
Absolutely.
So the three categories, is it your contention that you can only fall into one, or is it possible to fall into multiple of the three categories, 42, 46?
Your Honor, I suppose there's a world in which somebody could fall under the more than one category. That wasn't kind of specifically an issue in this case because Mr. Berry only fell into one category. The only category he could have been certified under, which was a third. His charges had been dismissed against him.
But he had also been committed. I know we have a different reading of that provision, but I mean, if you just look at the plain language of the statute, he had been committed.
But even under the second category, Your Honor, if we fall into the additional reasonable time period under D2, you only get the additional reasonable time period if the government, or if the district court makes a finding that in that additional time period, you could be restored. That didn't happen here, so it has to be part 2 of that, which is charges were disposed of. And here, those charges were disposed of, and WADA, the court has said that disposed of means dismissal.
So you want to read the time limitations that are in 4241D and import them into 4246A?
Not necessarily, Your Honor. I guess there are 2 different issues. So 4246A gives you the 3 categories, one being the Attorney General custody category. And if we look at when that period expires, you have to look back at 4241. And under 4241 for Mr. Berry, even if he were in Attorney General custody, the latest that would have expired would have been in December of 2019. There's an argument that it could have been earlier, but for the purposes of this appeal, the latest it would have been is December of 2019. The third category, the only category he could have been certified under, were charges that were dismissed against him for reasons of his mental health that happened at the same time. And then therefore, following on the reasonableness determination, there's clear error here because the court did not account for the fact that the government at any point since December of 2016 could have filed a certificate, and instead it waited until May 21st, 2020, and the government has failed to provide an explanation for such a long delay.
All right, thank you. Thank you for accommodating my question, Judge.
Thank you. We ask that you order Mr. Berry released.
I want to thank you because I see that you're pro bono here, and the court is especially appreciative of the good effort that you've put in for your client. Thank you so much.
Thank you, Your Honor.
We'll come down and greet counsel, and then we'll take a brief recess.
This honorable court will take a brief recess. The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit.
Please be seated. And we are going to hear our third case here, GW Acquisition versus Paige Limited Liability Company, Mr. Weisberg.
Thank you, Your Honor. May it please the court, Mike Weisbuck for the Brower parties. We've raised several issues in this appeal, but I'd like to start with our argument that Brower's cure should have precluded the district court's grant of summary judgment to GWA on its breach of contract and declaratory judgment claims. Of course, we also strongly urge that Brower should have at least gotten discovery on the claims that were dismissed at the pleading stage and that he should have gotten to a jury on the claims against Gadban, and I'm happy to answer questions on those points, but the cure is important because it should wipe out both of GWA's claims and any basis for any fee award to GWA. And there's really no dispute that the cure was timely, that it was within the window provided in the contract. GWA itself has referred to their February 27th letter as the notice of default. So if you calculate from there, the cure is timely. So the issue really boils down to waiver, I think. And there's no waiver here for three independent reasons. First, GWA filed an amended complaint 4 months after Brower filed his answer. And Brower raised the cure issue in the dispositive cross-motion briefing that immediately followed the filing of the amended complaint. So that's not really...
But that doesn't amend your pleading, does it?
Well, the amended complaint completely displaces the original complaint, resets the Rule 8 and Rule 12 deadlines.
I thought you were saying that you raised this for the first time in a where did you raise it for the first time?
So there's no immediate responsive pleading to the amended complaint because the parties stipulated to cross-motion dispositive briefing. So that doesn't implicate the Rule 8 requirement that you raise in affirmative defense in your responsive pleading because there's stipulated cross-motion briefing. So that's just not a waiver scenario at all. He raised it in his opposition to GWA's motion for summary judgment immediately following the filing of the amended complaint. So that's reason one. And these are three independent reasons, right? So even if you ignore that, the cure isn't an affirmative defense, right? As we say in our brief, this goes straight to the elements of GWA's claims because the contract itself says you can't declare a default or enforce the contract via a lawsuit if there's been a timely cure. So GWA says the first two elements of our claims are an enforceable duty and a breach. Well, here you have neither under the contract because of a timely cure. So an affirmative defense is external to the elements of a claim, right? But this goes straight to the first two elements of their claim. And then the third point, Your Honors, is the district court acknowledged that prejudice is required for waiver in this context under this court's Brinkley decision. But there's no prejudice here. There's no disputed facts. We know when the notice of default was provided. We know when Brower signed the rezoning form. There's no way that discovery could have made a difference here. And that's putting aside the filing of the amended complaint after the discovery window had closed, right? So I'm not sure how they can claim unfair surprise or inadequate opportunity to rebut when Brower raised the issue in his opposition to their motion for summary judgment right after they filed an amended complaint. So any of those three reasons is enough to overcome the district court's waiver holding and simply look at this straightforward cure within the window specified in the contract. And like I said, that should knock out both GWA claims because the cure provision says the party can't exercise the remedies described in the contract if there's been a timely cure. Well, what are those remedies? Any and all remedies in law or equity. So no nominal damages, no declaratory judgment, no attorney's fees. So for each of those reasons, GWA should not have been granted summary judgment on its two claims. Summary judgment should have been awarded to Brower on those claims. And of course, the practical effect of that, as far as the parties are concerned, is it wipes out the fee award, the large fee award in this case. So if there are no questions on that point, I can turn to Brower's claims. And I think with respect to the claims that were dismissed at the pleading stage, I can try to simplify things a little because I know there are a lot of claims. It can get kind of confusing pretty quickly. So in terms of the claims we're pushing, it's the same general fact pattern, right? GWA agreed or conspired with GADBAN that GADBAN would steer the sellers towards GWA in exchange for certain things from GWA. So that applies to the conspiracy to defraud and breach fiduciary duties and the tortious interference claim, right? Same general facts. Now, I think it's useful to sort of divide those facts into two parts. There's the conspiracy or agreement between GWA and GADBAN, that's the first part. And then the second part is what GADBAN allegedly did pursuant to that agreement or conspiracy. I don't think there's any dispute that we adequately allege the second part, that as sort of the primary wrongdoer in the conspiracy, GADBAN breached her fiduciary duties, engaged in material misrepresentations. She didn't move to dismiss the direct fraud and breach of fiduciary duty claims against her.
Are you dealing with the sort of core of Judge Brinkman's decision, which was that you simply breached the PSA, which obligated you to cooperate and support GWA in its efforts on the rezoning?
Right, so
You're accusing them of breaching the contract, but Judge Brinkman found that you had a contractual obligation to support GWA in its efforts to have the property rezoned, and that you didn't do that, you knew of documents that you had to sign, and you declined to sign them.
right, Your Honor. So that goes back to the cure point, but my client did ultimately sign the documents within
The point Judge Brinkman made was that when you sort of had to be forced to the table, and
Right.
that you only signed the documents to assist GWA when the court ordered you to do so. If there was, if the court hadn't ordered you to sign them, they would be unexecuted to this very day.
Right, Your Honor, but there's no litigation exception to a clear notice and cure provision. We've cited Virginia cases saying that even after litigation commences, a party can still cure, and it's not my client's fault that GWA jumped the gun and sued and got an ex parte TRO during the cure window. I think the court would basically be opening the door for parties to ignore clear cure provisions and rush to the courthouse when there's an alleged default, rather than following the plain terms of the contract that GWA drafted, right?
One thing we've consistently held is that these breach of contract claims, a breach of contract is not a tort, and yet, you've just strung along all these tort claims to the breach of contract claims. And what are you claiming? Tortious interference, unjust enrichment, and I guess other things, but normally we say that the breach of contract, for very good reasons, subject to its own rules of damages.
Right.
And we don't import tort notions and tort rules of damages.
Just to be clear, Your Honor, we're not pushing a breach of contract claim against GWA.
After these tortious interference claims
Right.
and unjust enrichment claims, you're not content with it being a breach of contract
We're not pushing breach of contract theories against GWA at all.
Well, but why all these tort claims in there? You want punitive damages for breach of contract?
No, again, we're not pushing a breach of contract theory. The theory is GWA agreed or conspired with Gadban, the broker, for her to steer sellers to GWA in exchange for certain benefits from GWA. There's no breach of contract there.
Judge Brinkman was concerned that you came to this with unclean hands, that you were the ones that had breached your obligations.
Right, Your Honor, but that view is inaccurate because,
Well, you signed the PSA agreement, didn't you?
Your Honor, my client, this gets into the summary judgment record.
You signed the PSA agreement.
My client signed the PSA agreement without full information.
And didn't the PSA agreement obligate you to use your best efforts to assist GWA in getting the property rezoned? I mean, you did sign the agreement.
Right,
You
and
were obligated under the agreement to use your best efforts. The district court found you didn't and had to be in listed ways in which you did nothing, and then said that in order, if whatever you were done because you had you had your arms twisted and were told to sign documents that you should have in the course of performance done yourself. And then you are coming along and accusing the other people of breach of contract, when the PSA agreement is before us plain as day, that you signed. And you did not follow through with it. And you thought, well, I can get a better deal elsewhere, and the contract was presented to us in conspiratorial terms, and we were unaware of this and that. You raise a fraud claim and everything else, but when you strip away all that, we're dealing with the fact that you were aware of this. You were told if you had a problem with it, don't sign it. But you signed it.
Your Honor, I think we're confusing the timeline of what happened. So to get into this is like the summary judgment record a little bit. My client did not have full information when he signed the contract. And regardless of what you think about our cure arguments, I think you're invoking this sort of futility exception that does not exist under Virginia law, and certainly is nowhere in the contract, which provides exceptions in the cure provision, but not for this.
The broker said repeatedly that if you weren't happy with GWA and with GWA's offer, then don't sign the PSA.
On September 7th.
You went ahead and signed it nonetheless.
Your Honor, that was September 7th. 3 days later, it's undisputed that the broker arranged a meeting with Kuhn, which appeared to violate the exclusivity provision in the contract, which was binding. And then the day before the deadline to sign the PSAs, she misleadingly threatened my client that he could be sued.
I thought there was a finding that Bowser was aware of the Kuhn offer or the other offer 2 months before you signed the GWA.
That doesn't go to the misleading threats that he could be sued for breaching the binding exclusivity provision. So page 66.
You felt like you could get a better deal somewhere else, and so you wanted to get out of this contract.
No, Your Honor. If that were true, my client would not have confronted.
The whole question of wanting a better deal and more money and feeling that your property under the PSA agreement that you signed was not, you weren't getting what you wanted.
Your Honor, that's for the jury to decide because the exclusivity provision, JA 669, all caps in the listing agreement says binding exclusivity. You can't negotiate with anyone else.
For 60 days.
For 60 days. So during that 60-day window, my client hears about the Superior Kuhn offer for the first time, immediately confronts Gadban. It's not seller's remorse when you go confront the broker as soon as you hear about this superior offer before signing the final PSAs and say, hey, what happened here? Why wasn't I apprised of this? And then, as GWA emphasizes, my client spent the next 6 weeks saying, I want to get out of this. I want to defect. And then there's evidence in the record that the day before the deadline to sign, she says, hey, by the way, you can be sued if you don't follow through and sign. And that's credible because they had a meeting with another potential purchaser that she arranged, which appeared to violate the binding 60-day exclusivity provision. So your sort of seller's remorse narrative that Judge Wilkinson, you're accepting that the district court went with, it's at least disputed on this record that my client wanted out of the deal before he ever signed the PSAs and felt like he was in a catch-22 as a result of his broker's actions and misrepresentations.
Well, I'm just wondering, you know, that you signed an agreement, then some information came along, that the agreement was, you know, hard negotiated, as contractual agreements are, and then after you signed the agreement, you were hit with a bit of buyer's remorse, and thought, well, I can get a better deal elsewhere, so I want to slip out of this one in some way. The record is open to that interpretation.
May I answer, Your Honor? I disagree that the record's open to that interpretation, but if the record is also open to my interpretation, and there's record evidence supporting my interpretation, that question's for the jury, not for the district court or this court. So, thank you.
All right, let's hear the other side of it.
Morning, Your Honors. May it please the court, I'm Michael Tucci on behalf of GWA Acquisition Company, LLC. I think, Judge Wilkinson, you've sort of hit the nail on the head, and it's the same nail that Judge Brinkema hit squarely on the head as well. It's a case of of seller's remorse, plain and simple. They tried to get out of the contract, and it didn't work at the district court, and it shouldn't work at this court. I will address briefly some of the claims that were made that first.
Well, they're saying that you hid all sorts of things from them and that you didn't tell them about the Keene or whatever offer, and that they were sort of blindfolded when they signed the agreement. And what do you say?
Well, the undisputed factual record demonstrates that that's absolutely inaccurate. What you just heard was that there was a 60-day exclusivity period on the GWA letter of intent. True. But the meeting that occurred in September with Kuhn and Gadban and the Pageland entities, they were all in that meeting, and GWA gave its permission for that meeting to happen. They went to GWA and said, we have this exclusivity. Would you allow us to meet with another group? We said yes. We allowed, that was Kuhn. We said yes. We allowed them to have the meeting. They had the meeting. All of the issues were aired at that meeting, and Brower still, at the end of the day, signed our deal. He had 6 weeks to evaluate the Kuhn offer and our PSA. And what did he do? He signed our PSA. So that's, that there's anything hidden here. I mean, talk about being most upfront as possible. How many developers would you know that would give an opportunity for their sellers to go meet with somebody else to see if they could get a better deal? We were the utmost fair-minded people in this negotiation.
Well, weren't they still obligated under the terms of the letter of intent to negotiate with you and sell to you if it was practicable?
Not if they had a better deal, they could walk away from ours. It was a 60-day LOI. So at the end of those 60 days, 2 things had to happen: sign our deal or walk away. They all chose to sign our deal. And the reason is, and it's all in the record, is that our deal was superior. There may have been a little bit more money on the Kuhn deal, but the conditions on our deal were far superior. It limited the development to data centers. It did not expand it beyond data centers, which the Kuhn deal did. And the reason that was important is because it was widely known that the only thing that this land would ever be rezoned for was data centers. So our deal had a better chance of going through to fruition, and I can happily report that the rezoning has happened and this project is moving forward.
I don't have a hard time seeing what Judge Brinkema did wrong. I think very well-reasoned opinion, but I think she got a little irritated when she had to order the folks here to actually sign documents that would have assisted in the rezoning effort. And she's sit there, you know, and she's sitting there ordering them to comply with the terms of an agreement that they had signed.
Black and white, terms of an agreement they had signed.
And, you know, that's an odd position for a district judge to be in. They don't normally order certain things as a matter of contractual performance. And, you know, I mean, I commend Judge Brinkham for doing it. She tried to get them to live up to what they had agreed to. And so they had a gun at their head, and they signed and they finally signed the documents. And, you know, Judge Brinkham at one point said, wait a minute, enough.
And Your Honor, there was a companion case after this case. We had to file in 2023 because the next document we asked them to sign, guess what? They refused to sign it too. So we had to file another lawsuit, and we got it sent to Judge Brinkham as a related case, and she enters an order saying, what's going on here? I ordered you to sign the documents in the last case. Why is this now back before me? Sign the daggum documents.
So we have to agree with you about this defense about cure and notice being waived, correct, in order to affirm summary judgment?
No, because there are several reasons why the cure doesn't apply here. The most important one is, what are we really talking about when we're talking about a cure? I think all of us would agree that in a normal contractual situation, a cure is something like you didn't pay your real property taxes under a mortgage, and here's a notice and pay the real property taxes. What happened here? 3 letters were sent to Paige Land to sign the rezoning forms. They ignored each one, filed a lawsuit, had to engage outside counsel, had to serve the lawsuit, which was difficult because the managing member of Paige Land was evading service at this time. We had to have a TRO hearing, which was duly noticed.
Well, let me stop you right there. Before we get there, once they fail to promptly sign the document, that's a default, correct?
It is,
And that's what triggers the notice requirement, doesn't it?
yes.
Okay, so I'm just trying to understand your argument as to why the cure and notice provision doesn't apply, if I understood your argument correctly.
Well, to be honest with you, it's confusing because the argument from the other side is we cured because of the TRO that was entered, but you didn't have the ability to ask for the TRO because you couldn't invoke your remedies until after the 30-day period. You can't have it both ways. You can't argue out of both sides of your mouth on this issue. There was a default, we sued, we got the relief that we were entitled to at that time. The 30-day cure period, or quote-unquote cure, doesn't apply to a situation like this, which is basically holding the entire development hostage over not signing forms and there's 12 agreements here. We're not just talking about one agreement. There are 12 agreements, and in all 12 agreements, we had to file the rezoning application on February 28th, and we couldn't file a complete application because they hadn't signed the forms. This whole project could have been scrapped because of that.
But you do argue that it is waived, this defense.
It is waived.
What are the relevant facts as it relates to the waiver issue?
Well, the first time this was raised was in a reply brief to our opposition to their motion for summary judgment. Okay? The first time this actual cure argument has been made has been in this court. It was never made in the district court. So it's waived for that reason. Another reason it's waived is because the failure of a notice and cure provision is an affirmative defense. It's never been argued, it's never been established that the affirmative defense was ever raised in the district court. So for that reason, it's also waived. the futility argument that's in our briefs as well. Futility does apply in Virginia. It's never been said that it doesn't apply in Virginia.
Do you have a Virginia case?
We have a Maryland case. It's actually the best one on it. And let me,
That was Judge Grigsby's case.
I'm sorry?
It's in the footnote of your brief, footnote number 6,
could be,
on page 28. This is Hippocratic Growth.
yes, yes. It's a well-reasoned decision that we rely on. And I would say that the two Virginia Circuit Court cases that are relied on by the appellants are, if you look at the cases, they're not applicable at all. They're apples and oranges. They don't apply here.
So it sounds like no Virginia court has recognized this futility issue, but it sounds like they also haven't rejected it.
Correct. Yeah, I think that's probably a fair characterization.
All right, sir.
If nothing else, Your Honors, I see my time is about expiring. We would ask that you affirm Judge Brinkman's decision. Thank you.
We're fine, thank you, sir. All right, Mr. Ross?
Good morning, Your Honors. I'm here on behalf of Ms. Gadban and her broker company, and Ms. Gadban is with us in the courtroom today. As you've heard, the essence of Mr. Brower's claim is that he was not timely made aware of an offer from Mr. Kuhn, but it's not disputed that he became aware of that offer long before he signed his contract with GWA. He knew that his LOI with GWA was non-binding and had an expiration date of 60 days, as Mr. Tucci was just referring to. And Judge Wilkinson, as you noted in one of your questions a moment ago, Ms. Gadban at a meeting repeatedly told Mr. Brower, if you're not happy with the deal, get out. And then finally, after that, she obtained for him a follow-up offer from Mr. Kuhn that he did receive. He had at least 5 weeks to review it. He reviewed it with his counsel numerous times and his trusted advisor, and he concluded to go with GWA, not with Mr. Kuhn. None of that is disputed. So recognizing that, what they do is they try to say, but when Mr. Brower signed the LOI, he wasn't aware of the prior Kuhn offer, and the LOI had an exclusivity provision, which Mr. Tucci talked a little bit about. But as with many issues in this case, Mr. Brower's own acts and deeds show that the exclusivity provision was of no moment to him. And let me, because this went on summary judgment, I want to highlight a couple of facts that were undisputed and came out of Mr. Brower's mouth. In the September 7th meeting that Judge Wilkinson was referring to and learned opposing counsel as well, Ms. Gadban told him repeatedly, if you don't like this deal and you want to go with Mr. Kuhn, get out. And she said finally at one point, be happy or get out. And what's very instructive is Mr. Brower's response. He said, fair enough, can't complain about that. Very telling, those are his words. And Ms. Gadban said, and if you get out, no hard feelings. Also undisputed that during that meeting, they discussed Mr. Kuhn's offer that he came to meet with Ms. Gadban about. And they talked about the fact, and Mr. Tucci alluded to this, that there was a zoning issue in Mr. Kuhn's offer that was far less favorable. The county was going to be less receptive to it. And there was no hard closing date. And importantly, Mr. Brower admitted both of those issues in the Kuhn offer were of concern to him. And then very tellingly, again, out of his own mouth, the very next day, he sent an email to a fellow seller, a person that he had reached out to prior to his meeting with Ms. Gadban on September 7th, and he was following up with that person after the meeting. And he said to this person, Mr. Abelhausen, he said, something I came up I thought you should know about, but I sat down with Mary Ann and Carter and got it explained to me. It was not what I thought, so disregard. Very, very telling, again, out of Mr. Brower's mouth. But after that, Ms. Gadban went the extra mile. She set up a meeting with Mr. Kuhn. Mr. Brower attended that meeting. As a result of that meeting, they got a follow-up offer. And as Mr. Tucci noted, that was done with GWA's consent, which is pretty impressive, frankly. Mr. Kuhn sends a follow-up offer. There's no dispute that Mr. Brower got this offer. He then had 5 weeks to consider that offer. His privilege log shows that on no fewer than 8 occasions, he had an email communication with his lawyer about that offer. He also admitted that during that 5-week period, he forwarded the GWA purchase and sale agreement, a red line version of it, to his trusted advisor, Mr. Dosky. And Mr. Dosky said, well, I don't have any concerns with it either. But then, on the day before the LOI was to expire, Mr. Brower had one last communication with his lawyer, and this is very, very instructive and very critical. And he asked the lawyer if he might get sued if he got out of the deal with GWA. Now, mind you, he didn't ask, he admits this, he did not ask whether he would have meaningful exposure if he did it. He just said, might I get sued? And his lawyer said, well, you might get sued, but you might not. And but what is that?
The record has it in those specific terms?
It does, Your Honor, and that is at 12:12 to 12:14, Your Honor.
Thank you.
And then, when asked in his deposition about that conversation, I said to him, and is that why you signed that discussion with your lawyer? Is that why you signed the purchase agreement with GWA? And he said, yes, as a result of that conversation with my lawyer, not with Ms. Gadban, I decided to sign the purchase and sale agreement with GWA, and that's also at JA 1214. So he's admitted that the reason he signed the agreement was his consultation with his counsel, not because of some after-the-fact supposed threatening statement that Ms. Gadban made. It had nothing to do with that. And the admission that he did it based on his conversation with his counsel eliminates any claim against Ms. Gadban or his broker company. It's all.
This all has a surreal quality.
It does. Honestly, Your Honor, it's a little bit, I was thinking about this, and I hope this doesn't appear glib to the court, but it's a little bit like whack-a-mole, because every time we would knock down an argument, something else would pop up, and it's all over the lot. But the fact of the matter is, he knew full well what he was doing. He had 5 weeks to consider this competing offer.
We're all well aware of moving targets.
I'm sure you are, Your Honor, yes, and that's exactly what this was. But he made a considered decision with 5 weeks to think about it, based on advice of counsel and his trusted advisor, had nothing to do with any supposed threats with Ms. Gadban, and he admitted that. He said, yes, I made the decision to proceed with the PSA with GWA based on that last conversation I had with my lawyer when the LOI would have expired the very next day. And although all of that is alone dispositive, on top of that, if Ms. Gadban had supposedly said, and of course she denies it, that she was threatening him that you'd be sued, that would have been non-actionable opinion. It's a statement about what might happen in the future by a third party. It's not something that could be acted upon, but Your Honors don't even need to consider that, because Mr. Brower, again, out of his own mouth said, no, I decided to go forward with the PSA, with GWA, a lot of acronyms in this case, sorry, based on that last conversation I had with my lawyer. Thank you, Your Honors.
No, I don't have anything. Thank you, Judge.
Thank you.
Thanks.
Your Honors, I've brought a portion of the record up here with me because it directly refutes the narrative that you've just heard. So in terms of what happened and GWA giving...
This is a very simple case, and that is that you, with full awareness, you signed an agreement, then you tried to get out of the agreement when you thought you had a better deal. You didn't conform with the agreement. Judge Brinkema had to force you to do what you had committed to in the contract. And then you have the gall of saying that these folks, these defendants, were somehow the ones that breached it and tortiously interfered and unjustly enriched themselves and committed fraud and everything. You had the gall to do that after you had signed an agreement and did everything within your power to slip out of it. And this is, you know, you're lucky you didn't get showered with counterclaims.
Your Honor, we were actually the ones bringing the counterclaims they sued, but let me just clarify the record. I understand your view of the case is unfavorable, but let me just say what the record makes clear, okay? It's undisputed that Gadban didn't disclose the superior Kuhn offer. We have evidence, sworn testimony that she threatened my client that he could be sued the day before the deadline. Now, they say, well, actually, this meeting with Kuhn that appeared to violate the binding exclusivity provision, GWA gave permission for that. But her threats were credible from my client's perspective, if you put yourself in my client's shoes, because he testified under oath that she never told him that she had gotten permission for that meeting. I can read to you from the record. Did you know that was because Mary Ann had gotten permission? I didn't know. No, I just know that she arranged it. And then in terms of the lawyer's advice, in that last day meeting where she threatened that he could be sued, his lawyer was on speakerphone. And the lawyer didn't just say maybe, maybe not. Remember, the question here is whether he could be sued for violating the exclusivity provision. That's what put him in the catch-22. Not whether he would definitely be sued, but whether he had to choose between risking a lawsuit because of the apparent violation of the exclusivity provision and signing the deal. So his lawyer said, I'm quoting again from the record, yeah, I could be sued. Will they sue me? Maybe, maybe not. So the lawyer said, look, yeah, it seems like what happened here is your broker arranged a meeting that violated the binding exclusivity provision. So you are in a tough spot. You either have to go forward with this deal, you could be sued because this meeting, no one told him that he had permission.
This has no relevance, you're just talking.
It's directly relevant to our fraud and breach of fiduciary duty claims against Gadban because she misleadingly threatened him. That's in the record. You can't, Your Honor, you can't resolve these disputes about the facts in the record on summary judgment. That's for the jury to decide. So on the cure point, the project could not have been unraveled as a result of my client not signing by February 28th. I want to make that very clear. The February 28th deadline was not a county deadline. It was in the same contract that GWA drafted containing this very clear notice and cure provision that they want to read out of the contract. And as you pointed out, Judge Maddox, they have no Virginia cases on this. Their Maryland case, the Hippocratic case, it's also distinguishable. The court in that Maryland case said, oh, actually, I see these other Maryland decisions have acknowledged there's no futility exception under Maryland law either, so I have to distinguish those. And they're the party seeking to invoke the notice and cure provision had actually affirmatively terminated the contract. So the court was basically saying, you know, at least when you go and terminate the contract that contains this cure provision, you can't turn around and invoke it. That's not the case here. And I mean, I just think generally the cure provision is crystal clear. And Judge Wilkinson, I know you're very concerned that Judge Brinkema had to enter a TRO. My client signed after the entry of the TRO. That is the direct result of them jumping the gun and filing a lawsuit during the cure window. They drafted this contract to have that February 28th deadline, which again was not a county deadline. And by the way, it didn't matter because my client cured within the cure window, but almost a month later. And when there is a futility exception that applies in these other jurisdictions, it only applies when the cure is incurable. Well, we know now the cure was curable because he signed the contract and everything went forward as they emphasized. The rezoning process is proceeding. Everything's good.
Thank you, sir.
Thank you. We ask that you reverse.
You okay?
Yes.
You okay? All right, thank you. We'll come down and greet counsel, and then we'll proceed into our final case.
Excuse me. Chair. There we are.
Are you okay?
Oh, yeah. Sure. Yeah, chair. I sat down in the chair. Thank you.
You sure you're okay?
I'm sorry.
I just don't want anything to ever happen to you. All right, we're prepared to hear our final case of United States versus Jones. Ms. Trodden, go ahead.
Thank you. Good morning, Your Honors, and may it please the Court. I'm Erin Trodden on behalf of James Jones. Mr. Jones raised 3 issues on appeal in this case. As to the first, sufficiency of the evidence, I'd like to stand on the briefing. As to the third, Rogers Singletary error, the government has conceded error and agrees that the proper result is remand for full resentencing.
That's on the sentencing issue?
That's on the third issue, the Rogers Singletary error in sentencing. But I would like to spend our time today discussing the second sentencing issue, which is the application of 2T1.1B1 and the tax guidelines for income from criminal activity. Should this court choose to remand, we would ask the court on remand to clarify the scope of this guideline, and in particular to recognize that it does not apply where the only criminal activity alleged as a requirement for that enhancement is a failure to pay the taxes the defendant was convicted of evading. In other words, where the defendant is convicted of tax evasion, the failure to pay the same taxes that he has been convicted of evading is not a separate criminal activity within the meaning of subsection B1. No cases have applied that guideline that broadly, and the structure and rationale of the guideline itself do not support such an application. So as an initial matter, the government does not dispute that a separate offense is necessary for the application of this guideline, of this enhancement. That's in their brief in opposition at page 50, but sort of throughout their briefing, they recognize that. The separate offense that the government relies on in this case, at least before this court, is violation of 7202 of the tax code. The problem is that that section governs failure to pay over required taxes. But that same failure to pay tax forms the basis
That's where he withheld from the employees
Yes, Your Honor.
with the money in his pocket.
He withheld the money.
Trust money.
Yes, the employee trust fund withholding. He,
When I was prosecutor, we considered that more serious than the tax evasion itself.
it's interesting because in this case, Your Honor, he reported the withholding to the IRS. And so for the purposes of these employees, they actually weren't out anything. Under the IRS guidelines, under the IRS regulations, they are treated as if they get that money. From their perspective, they're not out anything. It's the IRS that's out something, because they're the ones who are making good on this if the money is not paid over. But count 2, the tax evasion count, charges Mr. Jones with willful attempt to evade and defeat the payment of the employment taxes assessed to Lifeline Ambulance Service, as well as the trust fund recovery penalty. Now, the government is arguing that that same failure to pay over those taxes is also separate criminal activity such that this guideline should apply to it. But that's not sufficiently separate. The government argued to the jury, in fact, that this tax deficiency that their tax evasion conviction is based on is this very failure to pay over these taxes. None of the cases that the government cites apply this rationale, this extremely broad rationale. The closest that they come is United States versus Heard, which is the Fifth Circuit case. But Heard is meaningfully different. In Heard, the tax evasion is based on different conduct. Heard skimming money off of his companies and then enriching himself and evading paying taxes on that income. The criminal activity is separate from that tax evasion. It's not, the tax evasion is not based on the conduct that forms that criminal activity. The criminal activity is based on the failure to pay over the trust fund taxes. And so in that sense, Heard is distinguishable. It does not rely on the same conduct in the same way that this case does. Similarly, the district court in this case relied on United States versus Kearney, which is the District of New Mexico, the unpublished District of New Mexico case distinguishing Heard. Kearney is really, I think Kearney supports Mr. Jones's position here. Kearney is really about two things. One of them is about the definition of income, and that, I think, is a separate issue. In Kearney, the court recognized that those taxes where the defendant failed to pay tax on his own money, that wasn't income to him. But separate from that, Kearney also recognized that no case supported the broad proposition that failing to pay tax on the same taxes that you're then charged with evading gives rise to the application of this enhancement. And I think that is squarely on point for this issue here. The rationale of 2T 1.1b1 similarly supports this reading of the guideline, Mr. Jones's reading of the guideline. So we know what criminal activity is intended to be reached by the background to the guideline. The background in that states that this enhancement is included for deterrence purposes because this kind of income is generally difficult to establish because the tax loss in such cases will tend to be substantially understated. In other words, in cases where a defendant has income from criminal activity, from as in prostitution, as in the Fairchild case, or as in fraud or something else, it can be very difficult to ascertain what the tax loss is. And so this two-level enhancement is intended to be a proxy for that difficult to determine tax loss. But that's not an issue here. We know exactly what the tax loss is. We know, in fact, it's included in the tax loss that was attributed to Mr. Jones in this case. And so that...
Did you try this case?
I did not. Someone from our office did.
So he had public defenders
Yes,
all the way through?
yes. The tax loss already encompasses this loss from the criminal activity because it's the same criminal activity. It's the same taxes that he was convicted of evading the payment of. For that reason, there's no additional deterrence to be had from this. This guideline is included to provide deterrence. It doesn't provide any additional deterrence because the entirety of the criminal conduct is already encompassed within this. Mr. Jones is not someone who is like an Al Capone or like a Fairchild, which is the case involving prostitution that was cited in the briefing, where they've got a whole bunch of other criminal activity that they're engaging in, and they're not paying their taxes. All of Mr. Jones's criminal activity is related to this constellation of tax offenses here. And so for that reason, the guideline does not support the application of this. And it's fully encompassed within the tax loss in this case. but and I might add that with respect to the tax loss, the inclusion of the unpaid trust fund taxes in the tax loss calculation in Mr. Jones's case actually had a meaningful impact on his guidelines. In other words, including this money, which the probation office properly did under the tax loss calculation in the tax loss guideline, resulted in bumping Mr. Jones's tax loss up to another bracket. The tax loss that was calculated based on his improper deductions was around $1.4 million. Adding the tax loss is a little bit more. Adding the tax loss from the unpaid trust fund taxes bumped that up over the $1.5 million mark, resulting in a 2-level increase for him. So this conduct is actually, in practical terms, accounted for in his guidelines already by increasing his guidelines. Applying the criminal activity guideline in addition to this is really circular. It is counting the same conduct twice when it's already fully encompassed. Now, our position is that this guideline is not ambiguous, and that for that reason, for the reasons that I've discussed, it is clear that this conduct is not intended to be covered. And for that reason, also, the comment defining criminal activity would not be binding on this court. But if this court does find that the guideline is ambiguous, and I think there's a rational way in which the court could find that, but even if it does, with respect to the definition of criminal activity here, then it would still be, it would be under the rule of lenity in that case. That ambiguity should break in Mr. Jones's favor.
I just want to confirm that this wouldn't be double counted in every case.
No.
From your perspective, it's double counted in this case, but it would not necessarily be double counted in every case.
No, it wouldn't be double counted in every case. Certainly in a case in which you have the sort of mine run Al Capone situation, the Fairchild situation, that's perfectly appropriate, where the criminal activity is completely separate from any tax misconduct. That's not a problem. There's no double counting implicated there. This case,
Even if it was, double counting is not prohibited unless the guidelines specifically prohibit it.
it's not,
correct?
that is correct. It's not prohibited unless the guidelines specifically prohibit it, but courts can also look at the guidelines and what the intent of the guideline is and whether the conduct is fully encompassed within the other enhancements to the guideline in interpreting how this particular enhancement applies. And that's what we're asking this court to do here. Because Mr. Jones's conduct is already fully encompassed within the tax loss and fully accounted for by the tax loss, the application of income from other criminal activity really doesn't add anything to it, doesn't add any additional deterrence. It doesn't address the situation that the guideline is intended to reach as described by the background. Now, ultimately, if the court disagrees with that and finds that it's ambiguous, then we would ask the court to apply the rule of lenity. And I think that's the other way in which the court gets to this issue.
What if he had not been convicted or even charged with count 2? We would have the same guidelines, wouldn't we?
That's an interesting question. If he had only been convicted, I think that count 1, I will double check this, but I believe that count 1 would also have been under 2T1.1. Count 1 was...
Yeah, it would be under 2T1.1.
Right.
I think that if the government had presented the count 2 case at sentencing,
Right.
then you wouldn't have an argument, but we would have the same guidelines. And here, he was actually convicted of count 2, which arguably, if anything, makes it a worse case than that.
Well, count 2 is what they used for, the tax evasion is what they used for the basis of the guidelines. I think that counterfactual is hard to parse out in this case because he actually was convicted of count 2, and the government relied so heavily on this in their narrative of what his conduct was. When you look at what their argument ultimately was to the jury, they start out by talking about how he didn't pay these employment taxes and went on from there. And so, as a practical matter, looking at the conduct that they've alleged here, this is the same conduct as what they have argued. I see my time is about to expire. Are there any other questions?
Thank you very much.
Thank you, Your Honor.
You have some rebuttal time as well. Mr. Ellenwood?
Good afternoon, Your Honor. Todd Ellenwood for the United States. I'd like to start with the first question presented and just briefly address it and then rely on my briefs. The judge at the sentencing said that this is as blatant criminal conduct as this court has ever seen. At sentencing, Jones's trial counsel acknowledged the, quote, strong factual record and, quote, ample proof elicited at trial. In my brief, there are multiple categories of willfulness evidence. Any one of them by themselves is enough to support a willfulness finding. Cumulatively, it's a mountain of evidence. And if the court doesn't have any questions about that, I'll turn to the second question on the enhancement.
But he went to trial anyway.
Yeah, Your Honor, if I were to, I actually, in preparing for this, I tried the case. It would take me a while just to recite to you the exhibits that he signed that are what I, as a career prosecutor, rarely see individually. I mean, truly smoking gun documents. The statement of financial affairs. The bank records require them to know, not under any consideration for tax purposes, but post 9/11 money laundering provisions, who is the actual beneficial owner. So every bank account had records, and we got them through treaty requests, beneficial owner declarations. There's a mountain of those. There were multiple loan agreements that involved Mr. Jones's entities that he signed as the guarantor. There's a sale agreement with a person who testified at trial, Mrs. Paganelli, who says, I sold it to Mr. Jones. There are management agreements between him and the offshore, what I call like the nominee director. That person has their own know your customer duties, so he has documents that are signed by Mr. Jones, and one of them is called a declaration of no involvement in money laundering. He has one of those for every entity. It was a mountain of evidence.
But she doesn't contest the sufficiency of the evidence.
No, that's right.
She does contest it. She rests on her brief.
Yes.
But what about
So for the second one, for the issue,
enhancement?
yeah.
That you focused on.
So it seems to me that what Jones's counsel is trying to create is some sort of separate analysis for tax crimes that generate income. It's rare that a tax crime is going to generate income. Usually it's the failure to report and pay money over the IRS. That, we're not saying it applies to that situation. A run-of-the-mill income tax case, it's not applicable. So we agree that most failures to pay tax do not independently create income. That was noted in the Kearney decision. That's what Kearney was about. Kearney cites to a Ninth Circuit case, Ford, that said that explicitly. And that's because in most cases, a taxpayer's failure to pay tax isn't generating income.
And if it does generate an income, that's an appropriate aggravating circumstance that would justify a higher sentence.
You made my argument for me, Your Honor. Like, I think that that's exactly what it is. So when will this apply? And the most common situation is employment tax, because it's not just the failure to settle up at the end of the year or April 15th with the IRS. It's actually stealing the money that you have withheld from the employees. One of the most common charges for that is 7202. The guidelines do not have this enhancement under 7202. So if an employment tax case was brought only under 7202, it would not apply. It can apply in situations like here, where there's 7201s or 72061s, but filing false tax returns, or in Heard, where it was a 371. So here, the criminal activity was the embezzlement of the trust fund taxes withheld from the wages of the employees held in trust for the IRS. So to be eligible for this enhancement, there has to be some charge other than 7202 is the underlying criminal activity, but to be proceeding under the guidelines, the charge that the person was convicted of can't be 7202. And another limitation found in the Heard case that we rely upon is that the income must be attributable to the defendant. And I'm wary to get into kind of tax weeds, but in Heard there was discussion about that the money had to be diverted to Heard in order for it to be income. That's because Heard was a Schedule C business, a C corporation. A C corporation is a taxable entity. So if he had just left the money in there, he would have been committing the employment tax fraud, but he wouldn't be committing tax fraud or eligible for this enhancement if he had left the money in the business. The business would have paid the taxes on it. We had to prove, in order to convict him of tax evasion, that he actually pulled the money out for the variety of expenses that he did. We don't have to show that here. It's a S corporation where the money just flows through. So there was some discussion in the briefs about what was said at sentencing. Was it left in the corporation? Was it left in the business? Did we show personal diversions? We didn't need to. As soon as the money is withheld and not paid over, it goes into the business coffers, and that money will flow through to him. And as I think Judge Maddox was implying, not to put words in your mouth, Your Honor, but that here there is additional conduct, and that's why a lot of these other issues fall by the wayside, something like double counting. This court has said in United States versus Robinson, which is an unpublished decision at 456 FAPPX 283, page 291, because double counting occurs only when a consideration has been fully accounted for in another sentencing guidelines provision. And here, that doesn't apply. The additional bad conduct is the fact that he didn't report the money that he had stolen. And this court in Weiss found this to be the case. Weiss is not about the enhancement. That was not the issue in Weiss. The issue in Weiss was that Weiss was contesting his tax loss. The loss amount included a variety of things. The biggest one was the failure to pay over the employment taxes that he had taken from client companies. That was the biggest number. I think it was 4.1 million. Then on top of that was that he had failed to report that stolen money, and that was a separate offense. So in Weiss, this court said that the Sentencing Commission views the tax loss to the federal government resulting from the defendant's failure to report illegally obtained income from an underlying tax-related fraud as a separate and distinct harm from such an underlying fraud. It is distinct. It is different. Later in that opinion, on the same page, at page 216, the crucial point is that the underlying offense is complete when a defendant fraudulently diverts income to himself, so that when the same defendant fails to report such fraudulently obtained income as income on his federal tax return, a second and distinct offense is committed. I'm trying to think of other situations where this would arise other than employment tax. And one form of tax fraud that's coming down the pike is that out of the efforts to buffer the economy through COVID, there was a refundable credit called the Employee Retention Credit. And so this is money that's affirmatively given. It's not something that you just get to deduct from your taxes. It's money that the IRS is giving you affirmatively. And people abused it, and it was fraud. That could be subject to this enhancement. Somebody files a false tax return claiming the Employee Retention Credit. That is the crime. They also failed to report on their next tax return the fact that they got X amount of dollars out of the federal government illegally. And I found one case that I did not mention in my brief, but it's the Brandt case out of the Ninth Circuit. It's unpublished. It's at 480 FAPPX 450. And there, the defendant was convicted of 72061, which is filing a false tax return, and he did the same thing for clients, so that resulted in convictions under 72062. An additional fact was that with one of those false returns he prepared for a client, he stole the refund check. So the refund check was more than $10,000. The court there, had the enhancement, and the Ninth Circuit affirmed application of the enhancement there. That's directly the factual or the predicate that counsel's talking about. Oh, is there a case where it's kind of a rising out of tax and you do this additional enhancement on it? That one.
There's a lot of authority directly on point here.
No, there's not. There aren't a lot of tax cases.
We're plowing a new furrow, is what you say.
Could you say that again, Your Honor?
I said, we're plowing a new furrow. That's, when you plow the field.
Yes, Your Honor. I think it's pretty close to Hurd. I mean, Hurd, resolved this in, Hurd is the Fifth Circuit opinion. And it was about a page and a half long. It's pretty narrow, and it goes through the arguments that were made and says that Hurd stole from the IRS by withholding in excess of $10,000 in employment taxes in 2003 and not paying the money to the IRS. One other thing I would like to point out is that looking at the background and trying to decipher what it is that was the point of this enhancement, my counsel read the background provisions, but I want to go over it again. It starts out in the background: failure to report criminally derived income is included as a factor for deterrent purposes, period. The next sentence, and it doesn't slide into it, the next sentence says, criminally derived income is generally difficult to establish, so that the tax loss in such cases will tend to be substantially understated. I think those are two different things. I don't think it was the second one is related, and it is related to the first directly. And looking at the case law, I saw no cases that cited to this that said, in this case, it was very easy to figure out how much money the person stole from a Ponzi scheme. Therefore, we will not apply this enhancement to the tax charge. It's part of the background commentary. It says generally difficult. I don't think it is determinative in this case. And other cases have cited to that first sentence. Hurd said that the provision is included for deterrent purposes. The Third Circuit has said the enhancement is designed to deter and punish tax evaders who fail to report illegally acquired income. That's the main purpose of this enhancement. That's United States versus Vitale, 159 F. 3rd, 810 at 814.
Counsel, I think you've written a very thorough brief, and when I ask my colleagues if they have further questions.
No further questions, Judge.
We don't have further questions.
Okay.
Thank you.
Thank you, Your Honor.
Ms. Ellenwood.
Thank you, Your Honor. Just briefly, the court mentioned that the generation of income from illegal activity should be treated as an additional aggravating circumstance. But what the background is really getting at, and this is discussed in the Doxy case cited in the briefing, is not, this enhancement is not intended to apply because of the criminal activity. It's not correlated to any particular egregiousness of criminal activity. That's why it's the same regardless of what the criminal activity is. Instead, it's intended to be a proxy for the income that we can't determine what it is because it's from criminal activity. It's intended to be an enhancement because it's very hard to determine what somebody's income from ill-gotten gains actually is. And so in that sense, it's already fully encompassed by the tax loss that Mr. Jones was already attributed to Mr. Jones. So in discussing whether double counting is appropriate here, we do generally recognize that if it's fully encompassed, then there is no, double counting is not appropriate. And in this case, it is fully encompassed because we know what the tax loss is. And that tax loss, which we know because it's in the paperwork, the government relies on it, and it's calculated and it's in his pre-sentence report, increases his guidelines and does have a meaningful impact on his sentence. The government relies on the Weiss case.
Could I just, before you go there, Counsel?
Sure.
I guess the way that I'm sort of looking at it is that the first place where this is counted is tax loss. In other words, it's accounting for a loss of money to the government. It seems to me that the function of the enhancement that we are now talking about is it's accounting for a gain to the defendant. Do you think that that's an inappropriate way of looking at it?
I don't think that that's actually what it's intended to do, Your Honor. I think when you look at what the enhancement said, again, referring to this background provision that we've been back to, but it says, the second sentence, criminally derived income is generally difficult to establish, so the tax loss in such cases will tend to be substantially understated. An enhancement for offenders who violate the tax laws is part of a pattern of criminal activity from which they derive a substantial portion of their income, also serves to implement the mandate of the statute. So it really is focused on the tax loss. And that last sentence also suggests that this is really aimed at people who are engaging in separate activity. They're engaging in a pattern of criminal activity of which the tax violation forms a part. Here, for Mr. Jones, the tax violations are the entirety of his criminal activity. That's all there is. And that makes this meaningfully different. With respect to the Weiss case, it's really not, it's not about any of the issues in this case. Weiss is about grouping. In Weiss, the defendant was arguing about whether or not he was trying to analogize the loss calculation under 2B1.1 to the loss calculation under, was trying to distinguish that loss calculation from the loss calculation under 2T1.1. So it didn't address at all the application of criminal activity under subsection B1 here. The government has offered a number of cases and other hypothetical situations in which there might be additional loss or additional criminal activity that's also related to the tax evasion here, but none of those are actually this case. And I think that is really what makes this case meaningfully different, is that we have one victim here, it's the IRS, and that the tax evasion that Mr. Jones was convicted of, the taxes that he was convicted of evading, are the very same taxes that right here the government is also saying his failure to pay is a separate criminal activity. The government agrees that we need a separate criminal activity. There's no dispute about that. But it's not a separate activity. It's not a separate criminal activity here. When the government has argued to the jury that the government must prove the existence of a substantial tax deficiency, and this is simply the amount of employment taxes and trust fund recovery penalties the defendant did not pay. This was an element of this case for the government. And so for these reasons, yes, sir. Thank you, Your Honor.
All right, we will come down and shake hands with counsel. I'm going to ask the courtroom deputy to adjourn court, and I want to thank the courtroom deputy for the fine job that she did. And please adjourn court.
This honorable court stands adjourned until this afternoon. God save the United States and this honorable court.